So it's important when somebody's making a will, less so for that person themselves, but as a drafting solicitor, it's really important to turn your mind to these things, to understand the doctrines of undue influence, to understand testamentary capacity, and help protect your clients and their families from falling into that mess of litigation after the fact.
Welcome back to the Aging Vibrantly podcast. I'm Rayanne Rideout, the host of the show, where we amplify the voices of seniors and leaders in the field of aging who impart their expertise and wisdom to enhance our understanding of aging issues and ways of living a safe and fulfilling life with respect and dignity. In this episode, we're going to demystify the world of wills and estates. If you've ever felt overwhelmed by the legal jargon, confused about what a trust is, a will, or probate, you're not alone. The truth is, planning for the future is one of the most important things you can do for yourself and your family. National surveys suggest Canadians feel that wills are an important part of estate planning. Yet, less than 48% of Canadians have a will. So why are people hesitant or not taking steps to get a will? It's a conversation that gets put off again and again. But today, we're having the conversation that everyone needs to have. We often hear stories from people saying, I don't need a will. I don't have anything of value anyway. Or stories about families where an older adult may have been coerced to sign or change their will, leading to family disputes and long drawn-out court cases. Understanding the legalities of a will, undue influence, and court proceedings can be complex. So in this episode, we'll break down topics like what exactly a will is, why do you need one, what happens when you don't have a will, the difference between a will, power of attorney, executor, and attorney, having capacity to have a will. What happens when a vulnerable person is secretly coerced or manipulated into changing their will, leaving behind a trail of hurtful feelings, family, and legal disputes? We'll be exploring what undue influence is, the subtle and not so subtle signs that may be happening, and how to recognize it and challenge it in court, and proactive steps to take for ensuring your wishes are executed as you instructed. And this lively discussion will equip you with the knowledge to help you feel empowered and more informed about wills and estates. We are honored to have Whaley Estate Litigation Partners, or known as WEL Partners, a Toronto-based trust and estate litigation boutique practicing exclusively in estate-related matters throughout Ontario, joining us today. WEL Partners has been a long-standing supporter of elder abuse prevention Ontario and partnered with us on many educational webinars and conferences in the past to expand our knowledge about powers of attorney, guardianship litigation, and capacity issues, and much more. We are privileged to have two lawyers from WEL Partners joining us today. Both have extensive experience and knowledge on elder law, wills, and estates. Let me first introduce Joanna Weiss, who is a senior litigation associate at WEL Partners, wherein she primarily practices in the area of will, estate, and trust disputes, power of attorney disputes, and guardianship matters. Prior to joining WEL Partners, Joanna was a lawyer at boutique WEL firms that specializes in mental health litigation, estate, trust, and capacity litigation, and professional negligence. Joining Joanna is Emily Caza, who is also a lawyer at WEL Partners with experience in guardianship, capacity law, and estate litigation. Emily articled at the Office of the Public Guardian Trustee in Ontario, where she developed a strong interest in capacity and guardianship law and gained experience advocating for individuals lacking capacity. When she attended Queen's University, she worked as a case manager at Queen's Elder Law Clinic, offering free legal services to low-income seniors and gaining insight into the unique legal challenges faced by older adult clients. Lastly, I want to introduce my co-host, Pauline Leaning, who is a member of the Aging Vibrantly podcast Senior Advisory Committee. So welcome, everybody. So thank you for joining me today, Joanna, Emily, and Pauline. Given our passion to ensure that all people age vibrantly and safely, we're really looking forward to our conversation today around educating people about wills and understanding the roles and responsibilities of executor to ensure that their will is executed properly, and just even defining what wills and living wills are. I think there's a lot of misunderstandings of the terminology. I know from the work that we do in education sessions. So maybe, Joanna, we can start with you. We do a lot of webinars, as I said, and we've had WEL Partners in the past do education on powers of attorney for property and personal care. But one of the things that also comes up a lot is that often seniors or caregivers sometimes don't know the difference between a power of attorney, a trustee, a living will, and even the rules around the word attorney and executor. So maybe we can start with some basic clarification around what is a will versus a power of attorney.
Sure, thank you, and I appreciate the question. And to begin, I know that it goes without saying, but Emily and I are thrilled to be here and thrilled to be on the podcast and speaking with you both. Of course, anything that we do say shouldn't be taken as actual legal advice. I know that we're here to provide information, and we are happy to be able to do so. And it is a good question, and I would agree with you that there is often a lot of confusion. I think sometimes those terms that you've mentioned do get used interchangeably, and it might not be entirely clear in terms of how somebody is described, and also in what capacity they may or may not be acting. So I will start by taking a very broad stroke approach to it. So I'll start out with a will. So basically defining what a will is. And a will is a legal document that takes effect when somebody passes away. And it explains that person's wishes about how they want their property and possessions to be taken care of and distributed. So, for example, how much money should be paid to a specific person or a charity after they pass. And a will can also appoint one or more people to have decision-making responsibility or custody for children who are not yet adults. And the requirements of a valid will are found in a piece of legislation in Ontario called the Succession Law Reform Act. And the two most common kinds of wills are like a will that complies with the specific formalities in the Succession Law Reform Act, and also something called a holograph will. And a duly executed will in Ontario is a document that is signed by the testator or the testatrix, and that is the person that ultimately passes away. So basically, the person that actually signs the will and relates to their property. So they have to sign it at the end of the document, and it is attested to by two witnesses who sign it at the same time. And the will has to be in writing. The testator has to sign it or acknowledge a signature in the presence of two or more attesting witnesses that are present at the same time. The witnesses must also sign the will in the presence of the testator, and it has to be signed at the end after it's been completed. And the Succession Law Reform Act provides that a will is not valid if it's executed by someone under the age of 18, except for certain exceptions, such as if somebody is married or they're a member of the Canadian Armed Forces. So in very broad strokes, those are sort of the minimum requirements of what they call a duly executed valid will in Ontario. And holograph wills, which Ontario allows for, it's a will that's written entirely in the testator's own handwriting and is signed by them. So a testator can make a valid will just by writing it out in their own handwriting and signing it without the presence, attestation, or signature of a witness. And in terms of where the signature is placed on a will, whether it's a holograph will or not, it can be signed sort of after, following, or beside, or opposite to the end of the will. so that it's apparent on the face of the will when you actually look at it that the testator intended to give effect by signature to the writing signed as his or her will. So basically, like at the end of it, to sort of show that everything like above it or beside it is what they wanted as a part of their will. So very broadly speaking, those are sort of the basic requirements of valid wills in Ontario. And the only additional thing that I can say about just the on its face validity of wills is that in Canada, there's been many jurisdictions that have enacted validating provisions for wills that don't necessarily meet the strict requirements for due execution. So in January of 2022, in Ontario, what they call Section 22.1 of the Succession Law Reform Act came into force. And what this section does is that it allows a will that might have certain deficiencies or might have failed on its face when you just look at it because it didn't necessarily comply with the statutory formalities, that it allows the court, if it's satisfied that the document or writing was not properly executed or made under the Act, but it sets out the testamentary intentions of the deceased person or an intention of the deceased person to revoke or alter or revive a will, that the court, if you apply to the court, can actually make an order that the document is as valid and fully effective as the will of the deceased, that it actually is the valid will of the person.
So with the holograph will, is that something that someone can just do at home? Or, we've heard of people be on a plane and they think something's going to happen and they write down something quickly. Is a holograph will the same as a living will?
Yeah, so Rhiannon, that is a great question. And so a holograph will is sort of like exactly what you described in terms of someone, if they've got a pen and paper, right? Being able to write that. It doesn't really matter sort of what circumstance they're in, right? Like they could be on a plane, they could be at the grocery store or at home, right? Like someone, even if there's not some sort of imminent event that they think might happen, people can write it out on their own. And a living will, interestingly, and this can sort of dovetail into perhaps some information about power of attorneys. A living will is like sort of often sometimes like can also be interchangeably described as like an advance directive or some sort of end of life decision-making document. So living will is a legal document that stipulates what a person's preferences or wishes would be regarding end of life treatment decisions if they are to become incapable. And those documents may either request or refuse or sort of provide direction in terms of requesting or refusing certain kinds of procedures. And interestingly, there's no reference to advance directives or living wills in what they call the Substitute Decisions Act 1992 in Ontario, which is the legislation that governs or would set out decision-making on behalf of another person, or in the Healthcare Consent Act 1996 in Ontario, which also sets out the process for decision-making on behalf of others. So in Ontario, any sort of like advance directive or let's say preference in terms of end-of-life decision-making often ends up in what they call a power of attorney for personal care. So there isn't really anything in Ontario that is like living will specific or that would recognize a living will per se, and a power of attorney for personal care can set out a pretty flexible vehicle for assisting somebody with personal care decisions and sort of setting out what their preferences might be. So it actually is different than a will, and would be reflective of basically what people would want to have happen while they're alive and living.
Yeah, it's interesting. Thanks for that clarification, because I think people just use that term loosely, like living will. I think the will part is the confusing part, because it's you when you're alive still, even if it is an advance directive, right? And I think maybe we've used this terminology from other jurisdictions or other, from the States or wherever that. So we sometimes cross, utilize these words and not understanding really what their meanings are. And people say, well, yeah, this is legit. So I'm glad you clarified that. So thanks. And I think that's so important. One is, the will is when we pass away, right? And that's when the executor takes over, and the powers of attorney is your wishes when you are alive. And that's, we try to educate people around that, but it can be confusing. So that's when the trust or your executor with the will would then take effect. And that's who you would appoint when you're still capable in your will, when you're making your will. And does everyone have to go to a lawyer to make a will, or can you do a will at home? Like, we know that you can do your powers of attorney without a lawyer. Can you do the same thing with a will? Would that be a legally binding instrument, or a document, I should say, after?
Yeah, so it would be. So you don't require a lawyer to make a will. I know that there are will kits that exist, and I think like resources online for people that might want to do it on their own. I think it's not. I think that there can often be benefit to people speaking with or working with a lawyer when they do their estate planning. But let's say if somebody does their own will, particularly provided if it meets the other criteria, right? Like if it's in writing, if it's signed, if it's witnessed, then just because they didn't do it with a lawyer, that in and of itself doesn't invalidate it.
Okay. And I know later on we're going to talk a little bit about undue influence with Emily and stuff. And I think that may be the issue, that we encourage people to seek legal advice because we don't know if someone has forced them to sign something, or is this really what their wishes are. So having that independent legal advice is always recommended, I think. And we often hear people say, well, I don't have anything of value. I don't need to make a will. Why do I need to spend the money to do that? Is it important to have a will? And what happens if you don't have one?
Yeah. So that also is a good question, and I can understand why people might think that, right? And I think that the importance of having a will, sort of regardless of what you think about your property or your assets, right, is that if somebody dies with a will, then the distribution or of whatever they do happen to have, right, takes place in accordance with their sort of actual wishes and directions, right? So if you do have a will and you set out how you want things to be distributed to the extent that you have anything, then your directions in that regard govern, right? Like that is how your property or your assets should be distributed. And I'll just speak for a quick moment about the role of an estate trustee, which sort of can tie into having a will. Is so wills can include and often do appoint an estate trustee, or sometimes they're referred to as an executor. And that is the person that someone chooses to appoint to manage their estate after their death. So the estate or an estate is a legal term that's used to describe all of the assets, which it can include money, it can include personal property. So just the actual physical, tangible items in your home becomes a part of your estate, your personal items, and also real property. If you own a home or a condo, it encompasses all of that. So having a will can also provide people with some control and direction in terms of who they would actually want to take care of that. And your estate also encompasses your debts. So the estate trustee would also have to deal with any debts or liabilities that you might have. And they would be tasked with administering and defending your estate. So basically to kind of take care of all of that once you've passed, even if you don't have, even if you don't think you have much, people still probably end up having things that just practically speaking do need to be taken care of. And so if when somebody passes away, right, their property will pass to their personal representatives, which can be the estate trustee or the executor, and they will then be responsible for gathering all of the deceased assets, require title to them, basically take, find out sort of everything that the person has, everything that the person owes, and pay debts and outstanding taxes. And estate trustees can also arrange for, and often do arrange for, funeral and any sort of funeral or burial or cremation costs, and arrangements, which can be paid out of the assets of the estate. And when that's all done, then it's their job to distribute anything that's left over to those who are entitled to it in accordance with the directions of the deceased. And so if somebody passes away with no will, it's often referred to as somebody dying intestate. And that can sort of lead to questions of like who administers the estate, what happens to this person's stuff, who takes care of some of the things that actually need to be taken care of, right? And if you pass away without a will, then it's the law. It's and I know this is technical, but so it's Part 2 of the Succession Law Reform Act outlines basically what happens when somebody dies without a will. And it's actually the law. It's the actual legislation that determines who would be entitled to your estate, how much they're to receive, and also who can apply to the court to manage your estate.
So someone has to apply to the court to then be the executor.
Yeah. And
if they don't, then what happens?
Yeah. And so, I mean, it can become tricky, right? And I think that's where, sort of a benefit of having a will, even if you think there might not be much to take care of, right? Is that if you sort of let it all go to just the legislation by saying, okay, here's what takes over. It could be that at the end of the day, your estate is not distributed the way that you wanted it to be, even if you don't have much. Or it could end up being that somebody administers the estate that also you might not have necessarily wanted, right? One other important piece is that if you pass away without a will in Ontario, and if you are in a common law relationship, then your common law partner is actually not automatically entitled to inherit from your estate. So the default, if you are married, then if you pass away without a will, the surviving spouse gets everything. Like they would be the default beneficiary of the estate. And so depending on your life circumstances, right, it could be that your common law partner does not end up automatically inheriting. So a consideration for perhaps people that are in common law relationships is that if you pass away intestate, your common law spouse is not automatically entitled to inherit from your estate. If you are married in Ontario, then they would be. So that can be another consideration in terms of why somebody might want to make a will, such that if your common law partner survives you, they might actually have to, in essence, go through the court system in order to inherit from your estate if they wanted to. And so the structure of the legislation, the default in terms of who would get what, is that provision is first made for the surviving spouse, provided you're married, and descendants, and in essence, it sort of goes down the line in terms of, like if you don't have a spouse, or if your spouse predeceases you, then it would go to other descendants and keeps on going down the bloodline, ultimately through sort of blood relatives. And there's actually quite a lot of different tiers that it could go through, sort of depending on what someone's family structure is. And so it could be that sort of people that you might want to inherit from your estate don't end up inheriting from your estate if you pass away intestate. And lastly, to go back to your question, Rayanne, like ultimately, it could be that the court appoints somebody to administer your estate, which also might be inconsistent with what you'd actually want.
Mm. Yeah, it sounds similar to like the hierarchy of decision makers for personal care. Yeah. So you want to make sure that you appoint someone you want, because it could be somebody that does get into position of taking control of your as an executor that you didn't want to happen in the first place. So planning ahead is probably a good thing. So Emily, I think we're going to turn to you for the next question.
Can I just ask a question?
Yeah,
first?
sure, for sure.
Sorry. What I'd like to know, Joanne, is if you've made the will and it's all legally done with a lawyer and witnessed and everything is tickety-boo, and then several months later, you realize that you don't want somebody to inherit, or you want to change something, or you've had additional, say, grandchildren or what have you. Do you have to write a new will? Is it easy to adjust it? Can you just write a codicil? How does that all work if you want to change it?
Yeah, so Pauline, excellent question, and it does happen, right? Like people's life circumstances change, both for good and for bad. So there are absolutely scenarios where somebody might do a will, and just like you said, everything is properly executed and well thought through, and then something happens. Either somebody might have an estrangement from somebody that had been in their will, or there had been some sort of interpersonal conflict that sort of leads somebody to maybe question whether they want to change their estate planning, or maybe something a little bit more uplifting, that somebody has grandkids, or sort of new additions to the family, or they've had a friend that ends up assisting them if they've had some sort of health issue such that they want to provide for them, and so you can either do a new will, and there's no, I guess, fortunately, there's no limitation in terms of, waiting a certain period of time before you do a new will, or like a maximum number of times you could do it, let's say like in a year or a few years. So you absolutely can just redo it, or something like a codicil is also open to you if there are sort of amendments or changes that you wanted to make. That also is a possibility, and then that codicil would go along with your original will. Like they would sort of be part and parcel, so that people would know exactly what you wanted, and that would be something that I think, depending on the nature of the change and perhaps why you wanted to make the change, particularly if you did work with a lawyer to do the underlying will, they would probably be a great resource even to be able to go and say, okay, like what do you think makes the most sense here? Like how should I best go about this? But there are options.
And does the codicil have to be witnessed the same as the will would be with the two people?
Yeah. So the codicil to the will, right, which can be used, just as we had talked about, to make minor amendments to an existing will without creating an entirely new one. It would also have to sort of follow the same execution as the will. So signed by you and witnessed.
Protecting the financial interests of older adults is the goal we all want to achieve, particularly the ones who may be, cognitively impaired, or they have a decline in capacity. We know from experience with working with older adults that sometimes they're coerced by family members, or an instant new friend, or a relative that they didn't know they had before steps in and or a caregiver tries to exert undue influence. So they would leave their inheritance to the person who's sort of controlling all of this. Can you define undue influence for us, the legal definition?
Yeah, sure. First, I'll echo Joanna's gratitude. I'm excited and happy to be here and to talk about this topic. So I think that this is a really interesting area of law because the doctrine of undue influence is an equitable legal doctrine, which means that the courts have kind of created it and not any particular statute in Ontario. And it's a doctrine that's used by the courts to set aside certain inter vivos testamentary gifts. Obviously, for our purposes, we'll focus on those testamentary undue influence, and that's often used to set aside wills. So undue influence can occur where a person kind of exerts influence onto the will of a testator, and that testator's mind falls short of being wholly independent when making their will. It requires an element of an overwhelming persuasion that's akin to coercion. It has to dominate the will of another, and it forces the testator to act against their true wishes in creating their will, making testamentary bequests and gifts. Undue influence is usually at the hand of someone who has power over the testator, like you mentioned, maybe a caregiver or a child that's recently entered their life again. And under the law, the burden of proving testamentary undue influence rests with the challenger of the will on a balance of probabilities, and not the person who's accused of unduly executing that testator. In real life, that challenger usually looks like a person who was expecting to inherit under the will, but may have been cut out from the testator. Mm-hmm. An example of undue influence usually looks like a caregiver threatening to take away care if the testator doesn't change the will to make them a beneficiary. And that's kind of the level of coercion that it has to raise to for a court to make a finding of undue influence. I'm happy to provide an example of what undue influence would look like, if that would be helpful.
It would be helpful. Yeah. Thank you. Yes.
All right, great. So a typical scenario of undue influence could look like a mother who's living alone and she's suffering from some early signs of cognitive decline or dementia. Let's say she has two daughters, Emily and Joanna. Emily lives closer to mom and has kind of become what we call a de facto caregiver. She's not appointed by any power of attorney or anything like that, but she's over at mom's every day. She's helping her, she's providing her meals, she's taking care of her medication, and she's helping with her personal care and maybe paying some of her bills on her behalf. Joanna visits mom most weekends, but she's a busy lawyer and she doesn't have time to help mom the way Emily can be there every day, providing her that care that she needs, especially with that cognitive decline that's happening. So let's say after a couple of months, Emily brings mom to a drafting lawyer who's going to make a will and some new powers of attorneys. Emily also happens to be really close friends with that drafting lawyer. Turns out prior to that meeting, Emily told mom that if she doesn't change the will, which as it stands maybe gives 50% to Joanna and 50% to Emily. And Emily says, you need to give me everything or I'm going to stop providing you with care. And that's what undue influence looks like. It's truly that level of coercion. And and kind of that level of threat that it needs to be proved in order for the courts to kind of find that undue influence did occur and to maybe invalidate a will like that.
I would suspect that'd be difficult, would it not, Emily, in terms of, let's say it's Joanna who is going to challenge that to have what kind of evidence to, and we hear about these situations, like that scenario is not uncommon. And, you know, how do people deal with knowing those circumstances, but knowing like what do I need to gather to take that to a lawyer, to a court to contest that?
Yeah, so you're right. It is hard to prove. And like I've kind of been saying, usually it kind of involves a level of coercion. That's truly, if you don't put me in your will, I will take away care. And that's hard to prove. With somebody who has that kind of control over a testator and who is that dominant in their life to be able to exert that power, that kind of coercion, it's unlikely they're going to let anybody hear them say that. So that's kind of the issue in undue influence challenges. But this is kind of a good leeway to kind of some signs to look for that may be helpful in such a case of undue influence. And I think what's important here is that a finding of undue influence, it's really a question of fact. And that's made by looking at all the surrounding circumstances as a whole. So there's really no fixed checklist that exists that you need to tick all these boxes and then there's undue influence. But Ontario courts have considered some commonplace red flags, a couple of which I tried to mention in that example I gave. And they'll look for these red flags when determining whether a testator was truly unduly influenced. And for example, the Ontario Superior Court of Justice in a case called Gardona v. Gardona, it's a 2013 case, they noted some common indicators, including the testator being dependent on a beneficiary, the testator being socially isolated, so not seeing really any other caregivers or family or supports. The testator has experienced a recent family conflict or a death in the family. And that could look like I'm conflicting with Joanna. I'm not really letting her over to mom's anymore. And of course, if a death in the family occurred, that really often changes dynamics. The testator made a new will that's inconsistent with their prior wills. So usually prior wills will kind of show a long-standing testamentary intention. And then when that changes quite abruptly, that will raise a red flag. And the testator's made some other testamentary changes too, that are similar to the documents, such as a new power of attorney that appoints Emily, whereas maybe before it appointed both Joanna and Emily, or maybe some inter vivos gifts have been made to Emily and not Joanna. There's also another similar case. It's called Tate v. Guaguier. It's a 2015 case from the divisional court, and they found that some other facts constituted significant evidence of undue influence, and that could include, like I mentioned, some substantial pre-death transfers from the testator to a beneficiary. It could look like a testator's failure to provide reasons or an explanation for leaving an entire estate to one beneficiary where others had expected to inherit. It could look like the use of a lawyer chosen by the beneficiary was chosen by the beneficiary and was previously unknown by the testator. And in some cases, there will actually be documented statements that the testator was afraid of the person alleged to be unduly influencing them. And that a drafting solicitor should always look for signs and look for those common red flags. And that should be in a drafting solicitor's notes in any case. So, and one should also be alert to the testator's cognitive or physical vulnerabilities or impairments, including signs of neglect or distress. Those can be conflated with testamentary capacity, which does impact a person's vulnerability to be influenced, but those are distinct concepts.
Can you go on and say a little bit more about capacity?
Sure. So for a will to be valid, a testator needs to have the requisite testamentary capacity. Capacity is decision-specific, time-specific, and situation-specific. So, for example, the capacity to make a will is different than the capacity to make a power of attorney. Capacity also fluctuates. So, a person can have decision-specific capacity, like making a will in the morning, but come evening, they may not have that same specific decision capacity. And this can be typical in older adults who experience sundowning. And so that's important to turn your mind to. Even drafting solicitors, it might be prudent to schedule will executions in the morning and not later during the day. But when it comes to making a valid will, the testator must have had that testamentary capacity at the time of executing the will. So they can lose capacity after they executed that will. Like I said, capacity fluctuates. If they didn't have that testamentary capacity the day before, it doesn't matter as long as they have that at the time they signed the will.
And how would you test that? How would you know?
So, yeah, no, that's a good question. A drafting solicitor, it's their responsibility to turn their mind to testamentary capacity and make an assessment for themselves whether the testator has that capacity. And while there's no particular test, there are criteria articulated in common law and not in statute. There's a long-standing case. It's called Banks v. Goodfellow, and it authoritatively provides that a testator must have the ability to understand the nature of the act of making a will or other testamentary document and its effect. They must understand the extent of the property of which they are disposing, and they must understand the claims of persons who would normally expect to benefit under the will. So the term disposing mind and memory is sometimes used to describe that the testator, in essence, must have a clear understanding and memory to understand the essential elements of making a will. And again, that includes the nature of a will, the extent of their property, and the claims of persons who would normally expect to inherit. So me and Joanna see a lot of times people will come in and say, I don't think my mom had capacity to make this will. And then they want to start a messy, long, costly litigation. But the testator is always assisted with the rebuttable presumption of capacity. So the leading case on the presumption of capacity is called Rout v. Hay. It's a Supreme Court case back from 1995. And in that case, the court stated that if a will was executed with the relevant formalities that Joanna had mentioned when she was discussing a will, and if it was read over to the testator who appeared to understand it, that testator is presumed to have had testamentary capacity. So in court, in a will challenge, the propounder of that will, who will usually be the estate trustee, who has the responsibility of defending that will, they have the burden of proving that the testator had testamentary capacity, although that presumption really helps them overcome that burden or that allegation when in court.
Wow, it's very complicated.
It is. And
do you have statistics, or do you have any idea of how many of those wills would be overturned?
Oh, that's
it's.
I don't know if I have statistics exactly, but I think Joanna and I, and any estate litigation firm, can attest to how many times people come to our office and make these allegations. And like I said, although it's they're helped with the presumption of capacity, it always results in any case in emotional stress, costs,
Yes.
and ultimately breakdown of family dynamics. So it's important when somebody's making a will, less so for that person themselves, but as a drafting solicitor, it's really important to turn your mind to these things, to understand the doctrines of undue influence, to understand testamentary capacity, and help protect your clients and their families from falling into that mess of litigation after the fact.
Yeah, we often get, families will call and say, my sister just took my mom to the lawyer and it's changing things. And, it's hard to see both sides of this, the story, because we don't know, both situations. And, does this what mom wants, or is this someone just angry because they're going to be left out of the will? And, so I can see that you would probably get a lot of families coming when a person does pass away, and then there's this question back and forth. And so it's good to know that lawyers are taking their due diligence, I guess, is the easy terminology to use, and they're making sure that that person really does understand and why they're there, and who's actually bringing them. Did they come of their own means, or is there someone bringing them that's telling them to go and do this, and having that conversation and taking the time to have the conversation on a one-to-one with the older adult and the lawyer is so important to make sure this is exactly what their wishes are and what they want. So I can see the family, the dynamic. So let me just sort of getting back. I know that we talked previously, Joanna, about the common law relationship and some of those dynamics that happen or that break down when someone does pass away. But we are seeing a lot of older adults remarrying, and we see blended families and children from a first marriage, and then, someone passes away and the children are left thinking that it's going to be inherited. They're going to inherit the parents' property when in fact it may go to their person they're living with, whether they're married as a partner or just a partner living together for years. So how can people protect themselves in these situations, and making sure that what their inheritance that they want to leave gets divided or gets distributed to those that they want?
Well, I guess in situations like that, where there's a lot of blended families, difficult family dynamics, it's always important to remember that, I guess, the more layers of relationships comes resentment and competing interests, and they always just become more difficult to navigate. Inevitably, this makes litigation way messier and longer and just more emotionally charged for everybody. I think Joanna and I have been reiterating this, but properly drafted wills and testamentary documents are always the first line of defense. Although a testator is entitled to distribute their property in any which way they want after they die, there's always a fear that a disappointed family member is going to bring litigation in hopes of getting a cut. And to avoid this, a testator should know that sometimes they do have legal obligations to provide for persons after their death, and that includes common law spouses, stepchildren, and a lot of different parts of their blended family. I think Joanna may have mentioned, but under Part 5 of the Succession Law Reform Act, a testator has a statutory duty to make adequate provision for the proper support of their dependents. So a dependent includes not only minor children, but also adult children, including stepchildren, a surviving spouse, and that would be married or common law, and in some circumstances, even a parent or a sibling who is being supported by the deceased before their death. And in those cases, whether a deceased dies without a will, or whether they just didn't include one of those people in their will, so where no or inadequate provision is made, that dependent can apply to the court for support, and the court has really broad discretion to relocate assets to meet that obligation. And this gets us more messy and blended family situations. These obligations become more complicated. a common law spouse, a child from a prior relationship, and a stepchild may all kind of bring a dependence relief claim, and the estate can just become really quickly, can turn into a battleground, I guess. And with multiple parties asserting overlapping claims, that really quickly reduces the value of an estate, and family harmony. So I guess bringing it back to the main question, in these kind of blended family situations, what should be considered? Like I said, a carefully drafted will is always essential, but it's not sufficient on its own. Testamentary documents and wills, they should also be paired with thoughtful planning, and recognizing some obligations that a testator may have to dependents, to avoid some messy litigation. And it's always important to clarify intentions in any which way you can, and that might include domestic contracts before you even get to the will drafting stage. And hopefully that will help kind of untangle competing interests against your beneficiaries when the time does come.
That's great. Thank you so much for that clarification. That was really made me understand a little bit more.
Joanna, many people have heard the word probate used after someone dies when administrating an estate, but they may not understand the legal meaning or how it fits into estate administration. And is the case always probate? Is the will always probated? What can you explain all of that?
Yeah, absolutely. I'm happy to try to. But so in terms of what probate is, right? It's a procedure where you would ask the court to give a person the authority to act as a state trustee of an estate, and the court would confirm the authority, also apply to confirm the authority of a person that's named as the estate trustee in a deceased will, and basically formally approve that the deceased will is their last will, right? So sort of this is the valid will. This is who should be administering the estate, and that basically the estate trustee should administer the estate in accordance with this valid will. That's in very broad strokes, sort of what probate does. And in order to get probate, you apply to the court. So probate applications are now referred to as certificates of appointment of estate trustees. And what that does is so that certificate of appointment of estate trustee, it's also sort of interchangeable, or means, letters of probate, letters of administration, or letters of administration with the will annexed. Like that's what it is. And certificates of appointment of estate trustee are granted by the court where a person is named in the will as the executor, or to the next of kin on an intestacy. So that would be if somebody dies without a will, it's often could be the spouse, it could be the next of kin that applies, or actually also to a trust company. So you could actually have a trust company that is appointed as a state trustee, or somebody that is not a spouse, not a blood relative, somebody independent and neutral could also be appointed as an estate trustee. And in terms of when it's required in Ontario and how long it might take to get filed or actually get the certificate to give somebody the authority to start acting, it's not always required in order to administer an estate. And the types of assets in the estate usually determine whether an estate should be probated or not. So for example, if the deceased owned real property, which would be like a house or a condo or a cottage, or assets held by a financial institution, the estate often does have to be probated. And as most financial institutions will often require that certificate of appointment of estate trustee before they'll release assets in the deceased name. And so and similarly, I know that our office has had circumstances where if somebody had real property and it's sold, sometimes actually being able to close that sale does require that what they call the land registry office in Ontario, who they will often require some sort of like authority or a certificate of appointment of a state trustee, or sometimes what they call a certificate of appointment of a state trustee during litigation. So if there's ongoing litigation, somebody that steps in just during that litigation. But for certain types of things, kind of institutions or government bodies may actually require that certificate. And what the certificate does is it basically is confirmation of that person's authority to be able to administer the estate. So it can be really important to find out from, for example, financial institutions, what their specific practices and procedural requirements are. And in terms of, specific circumstances of when it might be required, when it might not be required, whether or not it's worthwhile to do. I would note that sometimes people try to do their estate planning in such a way that they won't have to, or that somebody won't have to apply for probate or a certificate of appointment of a state trustee after they pass. And I think that in terms of the intricacies of that, there are lawyers that are often referred to as estate administration lawyers or estate administration counsel, and they do this day in and day out in terms of advising people on sort of the estate administration aspect of stuff, and in terms of the length of time that it could take, it can range, and within Ontario, it can actually range based on where you are in the province. So I know that in Toronto, if you apply for a certificate of appointment of a state trustee, tends to take quite a bit longer than it would perhaps up in Thunder Bay or in Sudbury, or even sort of Windsor area. So I generally speaking, although there's no certainty because it goes through the court system and you get it when you get it. It could take anywhere from, and this is just a general ballpark, could take a month to a handful of months, just sort of depending on when you get it back from the court. And what I can add is that the probate application process is, in essence, to put it very bluntly, like a number of forms that you have to fill out, and it's done administratively. At least at the outset, and if the court comes back with problems or there's some sort of issue, they'll let you know. But that's why often people do use a state administration counsel for that reason, basically to make sure that all the paperwork is done right and that all the requirements are met.
And is it pricey?
That's an excellent question. I don't know offhand, to be honest. I know that there is a charge for it, like that there is a cost associated with it, but I'm off the top of my head, I'm not sure exactly how much.
All right, thanks.
Thank you so much for that. We have a couple last questions. So is there any sort of, Joanna and Emily, any words of wisdom that you might want to pass on to our listeners, particularly older adults, that you want to empower them about thinking about their wills or estates, and just based on your experience and what litigations that you have gone through, to prevent maybe some of these long court processes from happening and to protect the interests of the older adults? Maybe we can start with Emily.
Sure. I think empowerment often comes from knowledge. It's important to look for resources, talk to planning lawyers, and know your options. And I think that's ultimately what will give you some peace of mind, not only for yourself, but for your loved ones. I would also recommend, I think in some cases, it's a good idea to talk to your family members, and to talk to those people that you want to administer your estate for you, and to kind of temper expectations, So everybody kind of knows what to expect. They're on the same page. And yeah, again, I think that knowing your options is always the best way to be empowered. Yeah.
Thanks. And Joanna?
Yeah, I think to echo what Emily said, I think that generally speaking, sort of the for those that are doing their estate planning, I think sort of gathering as much information as you can. Speaking to lawyers, I know that that our website, so the WEL Partners website, has a whole resources page that actually has books that you can access online just by PDF and also ebooks that we've done our best to put it into plain language in terms of a lot of these issues and a lot of the law. So I think that there are a lot of resources out there that are quite easily accessible to people and doesn't necessarily require that you pay anybody for advice or information. But I think just equipping yourself with as much information as you can. And I would note just sort of generally that the main grounds, that there are really 5 grounds that people can challenge a will on. And that would be the failure to comply with the statutory requirements of due execution, a lack of testamentary capacity, the presence of undue influence, lack of knowledge and approval of the contents of the will, and fraud or forgery. And things like suspicious circumstances can play a part in all of this, that even though they're not an actual ground for a challenge, they can lay the evidentiary groundwork, or they're an evidentiary consideration that are relevant to the ground. So I think that as people turn their mind to it, I think in terms of trying to protect themselves, or at least trying to protect their testamentary wishes, to just sort of be mindful of, when I am no longer here and can't actually explain this for myself or defend it, if I want to make sure that this will sticks, and if I want to make sure that my family doesn't end up in court for years and basically squandering my estate on lawyers instead of inheriting it themselves, kind of how can I make sure that I, to the extent that I can, do my will independently? If I do want to disinherit someone, sort of chatting maybe with a lawyer to find out kind of how best do I do that and how to protect myself. And I think just sort of being mindful of setting things up in a thorough way, and just like Emily said, maybe speaking to family members about what your wishes are and what you want, so that it takes some of the guesswork out and hopefully some of the conflict out after you're gone.
Great, thanks. I was going to mention that we will post on our show notes, links to some of your resources and documents that you have on your website, because you do have a wealth of information and videos and tools on the WEL Partners website. So we will make sure that we'll list those as well. So do you want to ask our last question, Pauline?
Question. All of the podcasts that we've done, we ask this question to every single person that we've interviewed, and it's really interesting how similar the responses have been. So here it is. What advice would you give to empower someone, seniors that is, to age vibrantly? What advice would you give? Emily?
I think I might give you the one answer that's not too similar to others.
Probably will.
I think aging vibrantly, when I think of my parents and my grandparents and what I want for them, I want them to have peace of mind. I want them to have plans that are respected by their loved ones, in terms of their wishes about who's going to make decisions on their behalf. If they ever need that assistance regarding their personal care or property, or for them to pass with a peace of mind. And I guess the best way to do that I think I'll just continue to echo some of the themes me and Joanna have talked about. Educating yourself, and keeping open lines of communication with your family members about your wishes, and including that support system in any ways that they can help to carry out those wishes. I think that's really important to aging vibrantly. And yeah. Excellent.
Thank you. And Joanne, what is your advice?
Mine is probably not going to be nearly as eloquent or as thoughtful as Emily's, but I think probably twofold. And so this is coming from someone who is a dog owner who loves getting out in the world with my dog, and I actually think that one of the things that I can see of sort of a benefit of having a dog that actually needs to get out or wants to get out is, I think, as people age, that if you're inclined to have animals, to have them, I think it enables you to engage in the world perhaps differently than you would, and maybe fight off some of the isolation that older people can experience, particularly if they're aging in place and are not necessarily in communal living environments, or living with others. It could be that they end up spending a lot of time on their own, in their own space. So I think not only does sort of getting out with a dog perhaps keep you moving and keep you active, but offers, I think, a lot of opportunity to just socialize with people in the community. And I think lastly, and I know I know from my parents as well, I think just trying to surround yourself with others and sort of engaging in the outside world in any way that you can or want.
Lovely. Thank you.
That's amazing. Yes. The social connections, and, whether that's, pets or kids or whatever that takes to keep, out and about. And, I have dogs as well. So, every morning, that's the way that, just to get out and it starts the day, right? So, and, respecting your wishes and being empowered, as Emily was talking about, I think the more knowledge is power. So thank you both for your time today and sharing your expertise and your insights and understandings of the law. It's very complicated sometimes, so you're able to really explain the issues around wills and things around undue influence that we really need to consider and take and be aware of, whether it be ourselves or friends or neighbors that we might be aware of that something might not be right, to sort of maybe ask some questions or give them some information, let them listen to this podcast to get some further clarification on what they need to do to plan accordingly. So thank you again for so much for coming today. Thank you, Pauline, for co-hosting again. And we will again share all the information and links to resources in our show notes for people to get access to. So thank you and have a great weekend. Thank you, Joanna and Emily, for raising our awareness of wills and estate litigation. I encourage listeners to start conversations with your families, partner, friends about the importance of having a will, and if you haven't yet made one, maybe now's the time. Learn more about wills and estates by checking out WEL Partners' website, as they have a wealth of information available. Any reference to resources, programs, and services mentioned in today's episode can be found in the show notes of this episode. And follow up to protecting your rights and financial assets, why don't you check out the link to view Elder Abuse Prevention Ontario's website at eapon.ca, where you'll find fact sheets, brochures, and other materials on abuse prevention. The Aging Vibrantly Conversations to Empower Seniors podcast is hosted by Rayanne Rideout, produced by Lisa Whitterfield, and edited by Todd Miller of the Podcast Experts. The original music is by Red Path Audio. We want to thank Help Age Canada for their financial support to produce this season's podcast. Your feedback is so important in the development of our future podcasts, so please rate, review, and subscribe to Aging Vibrantly wherever you get your podcast. If you prefer to watch our interviews, full episodes are available on Elder Abuse Prevention Ontario's YouTube channel, or you can check out our website where the videos are also posted. Be sure to check us out at any time. Until next time, stay vibrant.